for capital formation, this robust framework instills unwavering confidence in global investors, propelling the nation forward with a newfound vigor as it advances onto the world stage. This is the transformation of Sri Lanka's capital market. 12 pillars, one vision, a resilient market driving a stronger, more prosperous Sri Lanka. In the heart of the Indian Ocean lies a nation ready for transformation. A nation of resilience, of ambition, of promise. At the center of this new chapter stands Sri Lanka's capital market, a powerful engine of growth. And leading this journey is the Securities and Exchange Commission of Sri Lanka, with a vision to be a benchmark regulator in the region. Our mission is clear: to nurture, develop, and sustain a capital market that is fair, efficient, orderly, and transparent. We are guided by 5 enduring objectives: robust regulation that safeguards integrity, investor protection through fairness and transparency, market development that unlocks opportunity, empowering knowledge and awareness, and institutional excellence in every endeavor. A vision is only as strong as the foundation beneath it. That is why the SEC has unveiled its strategic roadmap. 12 pillars. One vision, a resilient market. These 12 pillars form the lifeblood of transformation. Demutualization of the Colombo Stock Exchange, strengthening governance and efficiency. A vibrant corporate debt market, creating new pathways for growth. Innovative financial products, broadening opportunities for investors. Development of the collective investment scheme industry, empowering citizens to build wealth. Education, awareness, research, and training, fueling informed decisions. New listings, giving ambitious companies the capital to grow. Attracting new funds. Unlocking progress. Facilitating the implementation of a central counterparty mechanism, ensuring stability and trust. Establishing a multi-asset class derivatives exchange. Equipping markets with advanced tools, enabling effective regulatory frameworks, upholding fairness and transparency. Facilitate the digital transformation of the market, modernizing access for all. Enabling effective risk management in the market, safeguarding every participant. Together, these 12 pillars form the foundation of a resilient market, a dynamic engine that powers Sri Lanka's domestic economic growth. By utilizing the capital market as a key avenue for capital formation, this robust framework instills unwavering confidence in global investors, propelling the nation forward with a newfound vigor as it advances onto the world stage. This is the transformation of Sri Lanka's capital market. 12 pillars, one vision, a resilient market driving a stronger, more prosperous Sri Lanka.
Good evening, distinguished guests, esteemed speakers, panelists, and all participants. On behalf of the Securities and Exchange Commission of Sri Lanka, I warmly welcome you to this important awareness seminar. As corporate governance standards continue to evolve, directors of listed entities face increasing responsibility and scrutiny under the law. This seminar has been organized with the specific aim of deepening your understanding of directors' legal obligations and equip you to navigate the emerging regulatory landscape with confidence. We are privileged to have you with us today and a distinguished panelist, experts who will share their invaluable insights and knowledge on this critical subject. To commence this evening's program, it is my honor to invite Senior Professor Harindra Disa Bandara, the Chairman of the Securities and Exchange Commission of Sri Lanka, to deliver the opening remarks.
Good evening, ladies and gentlemen. Mr. Dr. Harsha Cabral, President Council, and today's keynote speaker. Panelists, starting from Mr. Laknath Jayavikrama, our own commission member of the Securities and Exchange Commission of Sri Lanka. Mr. Renuka Vijayawardena, former Chief Regulatory Officer and the consultant of Colombo Stock Exchange. And Mr. Bhuwanika Basnayaka, partner, FJ&G Serum, and Ms. Sunetra Dharmakirti, Registrar of Companies. Moderator, Ms. Chandani Veragala, Consultant Company Secretary. So, Nexia Corporate Consultants. Chief Executive Officer, Colombo Stock Exchange, Mr. Rajiva Bandaranaike. Chief Regulatory Officer of the CSC, Ms. Nilupa Pereira. And Directors of Securities and Exchange Commission, and our own Officer in Charge and the DDG of SEC, Mr. Tushar Jayaratne. Ladies and gentlemen, I think today's topic is very, very important for directors of listed companies. Mainly, you had a big role to play, and we need to understand the gravity of this topic when you look at the practical aspect of directors' liability. And this is an area critical for good corporate governance and market integrity. I think the importance of corporate governance is still there over 2 decades, and even at the moment it is a buzzword, not just a buzzword, it is more than that. It's a very important tool in the governance and the corporate setup. So, directors of companies bear fiduciary duties, legal obligations, and ethical responsibilities. Their conduct has profound implications for stakeholders, shareholders, creditors, employees, and the public. So, in a rapidly revolving regulatory environment, both locally and internationally, awareness of liabilities helps directors make informed decisions, avoid pitfalls, and steer entity responsibility. For Sri Lanka's capital market to grow, it must rest on the trust, transparency, and accountability. Directors' liability framework reinforce these foundations. So when we look at the SEC's perspective and priorities, the SEC is committed not only to regulation, but to build a culture of compliance, transparency, and good governance. As you all know, the SEC is committed to balancing market development with strong regulatory oversight, even though it is a bit difficult task. The directors must understand that directors' responsibility are not just about avoiding punitive measures, but about promoting long-term value, preserving reputation, and protecting stakeholder interest. So the key liability areas for directors, basically, so duty of care and fiduciary duty. I'm sure Dr. Cabral will explain all this nicely manner, but just to mention, acting in the best interest of the company, avoiding conflict of interest, making informed decisions. The statutory and regulatory liability, compliance with the SEC Act, mainly being regulated, and the listed entities, Companies Act, listing rules, continuous disclosure requirements, insider trading rules, and other relevant legislations. When it comes to corporate governance lapses, failures in oversight, risk management, internal controls, which can give rise to personal accountability as well. So misstatement and kind of non-disclosure, directors may face liability where financial statements, disclosures, or communications are misleading or incomplete. So risk of reputational damage also can be there, and loss of trust. So even if not legally liable, directors may suffer reputational harm that impacts the business and themselves. So in the capital market of Sri Lanka, why this matters for Sri Lanka's capital market? So when directors fulfill their responsibilities conscientiously, investors' confidence is enhanced, market participation increases, and capital formation accelerates. So that's why we need you to be more responsible. It's essential to shift the mindset from savings to investment and to deepen corporate governance as part of capital market development. As more companies, including state-owned enterprises, even though we have very few, there are more to come, I'm eagerly waiting for, look to participate in the capital market, robust director accountability becomes ever more critical. So then what directors should do, and what are the best practices we need to look into? So stay informed of legal and regulatory changes, seek external advice when needed, and ensure the board receives accurate, instantaneous, or timely and comprehensive information. Challenge management as appropriate. So maintain appropriate governance framework, also important. Board committees like audit committee, risk committee, nomination, and governance. Nowadays, the related party transaction review committee, internal controls and disclosures also very much important. And promote healthy culture of ethical behavior, transparency and continuous improvement, also among other things, and adopt proactive risk management, also important. Identify emerging risk, including ESG risk, cyber risk, and compliance risk, and ensure strategic oversight. So understand personal exposure also important. When things go wrong, the board and directors may be scrutinized, not just only the company. So when we look at the role of the SEC and support available for listed entities, the Securities and Exchange Commission of Sri Lanka will continue to provide guidance, capacity building, and awareness programs for directors and boards. Cooperations between regulators, corporate boards, professional bodies, and academics is very much essential to raise their standards of governance across the market. The message is not solely about regulation, it is about enabling sustainable growth of the corporate sector, enhancing competitive and safeguarding stakeholder interest. So I urge every director present to reflect on their role, assess their exposure, and commit to strengthening their board practices. Use this session to raise questions, engage in dialogue, share experiences, and learn practical steps that will strengthen your governance. So, in addition, the strength of the companies lies in the quality of its leadership. The strength of market lies in the integrity of boards. So let us work together to build a resilient, transparent, and dynamic corporate environment in Sri Lanka. In closing, thank you to all participants for investing your valuable time and energy in this awareness session. By enhancing your knowledge of director's liability, you contribute not only to your company's success, but also to broader goals of thriving Sri Lanka's capital market. So I wish you a very productive, insightful session and look forward to your engagement, and thank you very much.
Thank you very much, Professor Disa Bandara. Your words have set the tone for what promises to be an enriching and informative session this evening. It gives me great pleasure to introduce our keynote speaker, Dr. Harsha Cabral, President's Counsel, a highly respected legal professional, company director, and governance expert, who will speak to us on the topic, Understanding Directors' Liabilities in a Changing Regulatory Landscape.
Good evening, everyone. Professor Disa Bandara, Chairman of the SEC, distinguished members of the SEC, my fellow panelists and the moderator, very senior members. I'm honored to see very senior members in the profession, and I'm deeply honored to see my dear friend, Mr. Mohan Panditage, and several very senior members like Dr. James Swaminathan, who was my guru as well at one time. And so I'm deeply honored to stand here and share some thoughts on this particular topic. And I must also say that I'm thankful for SEC too, for inviting me. I believe after the 2007 Act came into operation, we had a couple of seminars, and SEC at that point too invited myself, Dr. Kanagiswaran, I believe Dr. Swaminathan also, to deal with this particular topic with regard to the, I would expand it to say, duties, responsibilities, and liabilities of the directors. So, getting into the topic, I must say, with regard to the SEC role and the listing rules and the Colombo Stock Exchange role, etc., has been discussed at several fora. I believe Renuka and I have done more than 10 to 15 seminars on the same topic. And it is very important that the SEC has taken a lead role in promoting this, in addition to the Institute of Directors. I see Aroshi Nanakara also, my friend, who is, I believe, the president of the Institute of Directors, for initiating this program in educating the directors, as continuous education on this topic is very important. We used to do that at the Institute of Chartered Accountants also, but unfortunately that died a natural death. Other than the Institute of Directors, I don't see anything that is happening. So it's very good. It's a healthy step taken by the SEC to invite the directors of listed entities to come and maybe get some more exposure on the new areas that comes into play. Now, when the Companies Act was incorporated in 2007, it's pretty old, it's not a new act, only the amendments came in a short while ago, but I was told that this will be minimal. I would not talk too much about because we have already had about 5 to 6 seminars on this topic as well. This is mainly for the company secretaries, so the directors will quietly palm off that responsibility to the company secretaries. But overall, when the Companies Act 2007 was brought in, it took a long while. It took about 6 to 7 years, the process of incorporating a new act. Because we've had, from the colonial period, the English law which governed company matters. The company law was essential English law, and we had the 1860 Joint Stock Companies Act, thereafter the 1938 Companies Ordinance, then Companies Act number 17 of 1982, which was a verbatim copy of the English law, and up to 2007 we had that English law in place. So the 2007 Act, when it came into operation, when we drafted that, we were given 10 position papers. We worked on 10 position papers, how exactly we should change the law in a changing world. So there was this World Bank sponsored gentleman, Mr. David Goddard, who came from New Zealand. And New Zealand by that time had got a brand new Companies Act. And we used that because that was based on the Canadian model law. As we all know, the old English law, the traditional English law, maybe the senior members would remember the old companies like George Stewart's, Brown's, Walker and Grigg, British Car Company, so on and so forth, had even the plantation companies, the Britishers control. So the old English law thought that companies are managed by very honorable people. There is a case law about 100 years ago which says, Lord Eldon has said, the court should not be called upon to interfere in the day-to-day management of the playhouse and the brewhouse. Those were the two big businesses at that time in England. Playhouse was, Shakespeare drama and so on and so forth. But brewhouse is big business even today. So it had continued. So courts did not interfere because companies were managed by honorable people who were called gentlemen. But as time went on, this gentleman thing vanished. Even now when you look at it, it's very difficult to find gentlemen. We know when we have looking for independent directors, for that matter, even a gentlewoman is difficult to be found, not only gentlemen. So, but as time went on, across the Atlantic, the story was different. Because the most regulated first stock exchange is the New York Stock Exchange, started first in Switzerland, but thereafter in New York, the first one, most regulated one, they brought in a lot of regulation. They thought this English company law concept of gentlemen running business is no good. Companies are managed by crooks. So we have to regulate them. So highly regulated atmosphere was introduced by the New York Stock Exchange. So Canada, like another country like Sri Lanka, which had the same story like following the English law, what they did was they were influenced by the old English law on one side, and from the US, the more regulated company law. So they hired the best brains in company law. The Professor Gower was Gower's company law is the Bible in company law. Professor Gower and several other jurists, the best brains on company law, to come and study what this English law concept and the US concept. And the Canadians came up with the very first hybrid model of much regulation. It was first the Ontario Business Corporations Act, thereafter the Canadian Business Corporations Act, which was the more modern company law with a lot of regulation. So this model was followed by Australia, Canada, Japan, South Africa, and even England. The England Law Commission said, our law is more outdated, and we have to look at, anyway, the European directives, EC directives came in after it became a European community. And then they introduced even the present law is based on the Canadian model law. So the Canadian model law is the role model for this, and we were fortunate in 2007, we followed that in formulating our own laws. So from 2007 onwards, I must say, the traditional company law is minimal. We have more modern regulated company law, which has brought in a whole lot of new areas, and one is directors' duties and liabilities. One position paper was that. So in that, we had to introduce a whole lot of new things hitherto were not there in the company law. Whereas to understand what was fiduciary duty, what is acting in best interests, we had to look at English common law cases. So who a common man is, who a normal man is, we had to look at the Clapham Bus Company case to see it was decided that a passenger in the Clapham Bus Company, a traveler, was supposed to be a reasonable man. So all that was based on case law, but from 2007 onwards, under our law, under the new Companies Act, they are all statutory. Very easy, it's in black and white. So firstly, I must say, we brought in a section called Section 185. Basically, the Companies Act has 534 sections, 13 schedules, and 46 forms. In the time of questioning, you're free to ask any question from any section. I might be able to say something because I know that is the importance of when you are drafting, it goes to the head. And more than that, when you write books, it registers here. So that is the beauty of learning. And so a section was brought in for the very first time. Section 184 specifically says that companies are to be managed by a board of directors. Shareholders don't run companies. That's the simple principle of company law. If shareholders were to run companies, Haley's would be managed by thousands of shareholders. Shareholders appoint a board of directors to run the company. So 184 very specifically says so in our law, that the company is to be managed by a board of directors. Then there's another section, 186, very specifically says there are certain things the board of directors can delegate, and there are certain things they cannot delegate. So there is a schedule 6, read with section 186, list out the responsibilities of directors which cannot be delegated. You may have your subcommittees, as Professor mentioned. There are several subcommittees now for listed companies, and that is getting added. We had the related party transactions committee also added, where you can delegate to that, but ultimate responsibility lies on the board. So there are different concepts of running companies. There are some big companies, international companies, where they have appointed, board appoints contracted CEO, contracted COO, contracted CFO, they are answerable to the board, but they are on contract. If they don't perform, they are kicked out. Out they go. But in Sri Lanka, we have the board system. Some jurisdictions have two-tier boards, but in Sri Lanka, we follow the one board system. And the shareholders appoint the board to manage the company. And internal running, all that, the constitution is our articles of association. The articles of association will tell you, it's like the constitution. In New Zealand, it's called the constitution of the company. Like a constitution of the country, all the internal things, you will have a chairman, you will have a director, you have several X number of directors, maximum number, minimum number, how you appoint directors, remove directors, shares and meetings and so on and so forth will be there in your articles. But articles are under the purview of the Companies Act. You can't have articles overriding the principles of the Companies Act. So you've got to keep in mind, in most of the we as practitioners, we know when there are problems with companies, when they have the directors, among directors fighting, shareholders, majority shareholders fighting with minority shareholders, which brings in work for us. When the directors come in most of this, first thing I ask is, have you brought your articles of association? They know that there is a document like that, but some have not even read it. So that's the number one. You must know your articles of association. So company, you appoint a board of directors and with authority and with also the shareholders have given the power for you to do the day-to-day management of the company. You run the company. So the board appoints a chairman. So chairman, if you have executive chairmen, run executive chairmen. It's a fairly tough job. I know my friend, Mr. Mohan Panditake, is there 8 o'clock in the morning in office. He's there 8 o'clock in the evening in the office. Then thereafter at 10:30, 11, you could see him entertaining principals at Kingsbury. That's a tough job. It's not easy. The executive chairman. So I think Mr. Dambik Pera's biggest asset is Mr. Panditake, because you can't find anyone else to do that job. I can't do it physically. I don't know how he has the stamina to do it. So we have a team of directors, a board of directors to run the company. Now, as far as the Companies Act is concerned, they talk about the board of directors and director. In the Companies Act, nowhere in the 534 sections you find the words executive director, non-executive director, alternate director. You find that in your articles, not in the Companies Act. Nowhere in the 534 sections you will find the word independent director. That comes from your regulatory element, from the securities regime. So as far as the company law is concerned, under the definition of a director, 529, you have the definition. The director definition is very wide. It runs into a couple of pages. A director named in the form, a director who is responsible in running the organization. Sometimes you may not be called a director, you are a country head, but even that person can be held as a director. So that definition is very important. If that definition fits, that person will be a director. Because sometimes you find all the members of the board overseas. You have a country manager here. He is responsible. He will have to go to the magistrate court for non-payment of EPF, ETF, so on and so forth. So the director definition is very wide. So people must know, even puppeteering, you may be caught for director. You have the control test and so many other things that come up as who a director is, even if you are not named a director. So that's very important. So when you become a director, you have to be cautious about that. Because in the Companies Act, to be a director, you don't need any qualification. If you are not insane, if you are not charged for certain couple of things, you can be a director. Even reading and writing is not a requirement to be a director. So any dumb fellow, idiot can be put as director. So if the shareholders put stupid fellows as directors, you can expect what the results are. So anyone can be a director. Like doing politics, becoming MPs, ministers, you don't need any qualification. So to be a director, you don't need any qualification. But to be a company secretary, you have to be qualified. To be a company secretary under the regulations, you have to be a chartered accountant, a chartered secretary, or an attorney at law. Only exception is that's in the regulations, which says that if it's a private company where the share capital is below 500,000 or the annual turnover is below 1 million, you don't need that qualification. So you have that responsibility cast on the company secretary. Big responsibility. Now with this Amendment Act, that responsibility becomes heavier for the company secretary. I will touch on that towards the latter part. Now, then comes the auditor. I just finished a session at the Institute of Chartered Accountants where some people were here, and there again I had to frighten the auditors and come before coming here. Their role as auditors, the statutory role as auditors, large number of auditors, all sorts of questions. Our former chairperson is also there, and the role of auditors, because there are so many statutes. You have the Companies Act, you have the Accounting and Auditing Standards, you have the SEC Act, you have the Monitoring Board, then chartered accountants have their own regulations, internal regulations, then you have the National Audit Act for public sector organizations. So the roles are fairly heavy. That is, again, you have a qualified person as an auditor. You have a qualified person as a company secretary. Then you might have not so qualified people in boards. So it's important that the shareholders appoint the correct people to be on boards if they want results in the correct manner. It's like this. Even if you appoint, if the principal and the staff in a school, institution, educational institution, if they are not strong or good, well, you can't expect good results. Same with your own family, with the household. If your father and mother they are not exemplary, you can't expect the children to be exemplary. So this is like a normal household when it comes to a company. Now, more than that, we have very crucial provisions brought in the Companies Act, which provide specific guidelines in black and white to the directors to know what their role is and what their liabilities are. Duties, responsibilities, and liabilities. 187 of the Act very specifically says a director, when you're on the board, must act in the best interests of the company and act in good faith. Very simple. Now that's set in black and white. Earlier I told you what is good, acting in good interest, what is fiduciary duty, best interests of the company. All that had to be plugged from case law. Now you don't have to go that far. 187 very clearly says, act in the best interests of the company. So you must know what the best interest of the company is. And act in good faith. Like a father looking after the family, you have to, when you're on the board, you look after your company. Now acting best interest means, there is one exception. If you have a holding company and a subsidiary company, and if you have been nominated by the holding company to be a director of the subsidiary company, when you are on the subsidiary company, whose best interest will you look after? When I teach my students, I ask this question. All right? I won't embarrass you from asking that question. If you're nominated by the holding company and you're in the subsidiary company, whose best interests are you going to look after? You will say, well, that company, you have to look after the best interests of the subsidiary company. That is the company you're in. Now, there can be a situation where the holding company has created this subsidiary company to, say, manufacture a battery. And the idea was, so the manufacturing cost of the battery is 1,000 rupees. They sell it to the holding company at 1,500. But if they sell the same battery to the outside world, they can sell it at 2,000. So now when you are on the board of the subsidiary company, if you are acting in the best interests of that, you have to sell it to the outside world. But if you do that, your parent will cut your nomination for not looking after the interest of the holding company. So that exemption is there in 187(1), which specifically says you can look after the interests of the parent company if the subsidiary is a fully owned subsidiary, not otherwise. If it's a fully owned subsidiary created to manufacture the battery and give it to you, that's fine. Otherwise, you have to look after the interests of that. So 187 is very, very simple and clear. Then comes 188. You have to just follow the provisions of the Articles of Association and the provisions of the Companies Act. Very simple. You have to you can't breach them. You have to follow the Articles of Association and the provisions of the Companies Act. Now, hypothetical example, if you can't read or write, you can't do that. If you are not seen your Articles of Association, all these people, all your companies, they have Articles of Association. Updated, amended Articles of Association, latest copy given to the SEC and to the Registrar of Companies. So, you have to know what is there in your Articles of Association, not to breach them. So 188 is simple. No problem in that. Then comes 189. The standard of care that is expected when you are on a board. What is the standard of care? You should not act in a reckless or negligent manner when you are on the board. Right? I told you, like a father looking after the family, you got to do that. Not to act in a reckless manner. The best you have to. So 187, 188, 189, even if you forget all the other sections, 535, I know most of the directors don't have the time to read all that. But if you actually understand 187, 188, 189, act in the best interest of the company, act in good faith, follow the provisions of the Articles of Association and the provisions of the Companies Act, and the standard of care, not to act in a negligent manner, at least you're safe. So at least those three sections you've got to keep in mind. So that is the liability that is coming in. That's the main liability that comes in. Those three sections. But on top of that, you have from 191 to 200, which brings in conflict of interest. Conflict of interest in contracts, conflict of interest in shares. Now this is where it becomes stronger when the SEC, the securities regime, comes in. The SEC Act is there, the CSC rules are there, CDS rules are there, CSC listing rules. That becomes, you bring in insider trading. That is all due to conflict issues. Conflict can arise either on contracts or on share transactions. Now, how can there can be contracts in shares. So, say, I am on the Tokyo Cement board. So, they have to buy, say, those mixers, those lorries that keep on rolling all the time, right? So, they have to call for 3 quotations. So, 3 quotations will come from Ashok Leyland, Tata, and say another Chinese company. So when this comes onto the board, now I'm a non-executive, I chair the board, it runs, no sooner I see this, Tata agents are demos. I'm on the demo board. I have to immediately say, please record that I have a conflict in this matter. I will not take part in the decision. Not only myself, there is another, Mr. Talvat is also on the board. So I have to say, both of us will not take part in this time. Now, for good reason, no reason, bad reason, they might award the tender to maybe to demos or anyone else. If I have not done that, any shareholder can take me to task. So if I have not recorded that, and that is why your minutes are confirmed at the next meeting. Even if you are missed at the first meeting, when it's corrected, you have to say, no, I have mentioned that I have a conflict of interest. Sometimes it's very difficult when you're on banks. I can remember we have HNB CEO is here. When I was there, you have to divulge every time because all the other companies, you have dealings with that bank. Either it's Haley's or Demos or whatever. So every time you have to be very, very careful. First thing you do is get the board papers and see where do you have conflict. So I get the post-it notes and at the outset itself I say, Company Secretary, please record that I have a conflict of interest in this. I will not take part. Long years ago, they didn't not only record that, they got up and went out. They didn't want to be a party to that. But now at least if it is recorded, you have satisfied the requirement. They may award it, that's a different thing, but you have recorded. There was one particular instance now with the State Bank. If you're involved in public bodies, Dr. Roshan knows, the responsibility is heavier. Because you're taken to the COPE and Bribery Commission and Presidential Secretariat and Ministry of Finance on anonymous letters. There was one particular thing that came up, and fortunately, I had recorded that I have nothing to do with that. I have not voted or supported or anything. So you have to be very, very careful in recording. That is why minutes are absolutely important. Minutes are taken as a contemporaneous record of what transpires. You may use it in court 5 years later, 10 years later in court, that you have recorded, no, you have not participated in that. If you don't do, you're asking for trouble. Then the other one is conflict in share transactions. Just now also a friend of mine asked another question. When you're in a company, and if this company is going to buy shares from another company, where your wife is on that board, you have to immediately divulge that. Or if you also sizable stake in that company, you have to immediately inform. Record that I will not take part in that transaction, especially companies buy shares. If you don't do that and someone complains, you will get a love letter from the regulator. You have to face the music. You see. So you've got to be very careful from 191 to 200 what this conflict issue is all about. Conflict in shares, conflict in contracts. It becomes wider when it comes to insider trading. I was very lucky. I was under my guru, Dr. Kanagiswaran. 40 years ago, he told me, let's stick to what we know. That is basically to con in quotes. Right? He said, we will not dabble in shares. So much so I don't buy or sell a single share. So when it comes to listing companies, the declaration, nil, nil, nil. I don't buy or sell a single share. Otherwise, all these companies get letters for the slightest thing. So you have, you have the right. Now, a lot of people at this, as independent directors, when you are there, this, the normal AGM people, they very common question, your independent directors have not bought any shares, that will strengthen our position. I said, no. Leave me out, I won't buy a single share. So there is no conflict. So insider trading is a very important thing for directors to keep in mind. It can happen. You have tightened the screws now because you are privy to a lot of inside price-sensitive information, which your shareholders are not privy to. Shareholders are not privy to the board minutes. Directors are privy to price-sensitive information. It's very easy to do. You are planning to declare a dividend. You don't use the phone now. Now, people are very smart. You don't have to use the phone. You don't have to use things. Well, after this meeting, I go to a friend's place. I don't use the phone or anything. I give him 10 million rupees and say, you go and buy shares tomorrow, knowing very well that the share will go up day after tomorrow. And my 10 million becomes 20 million in 4 days' time. And we share the loot. I just give that fellow $1 million. He'll be very happy he's getting nothing for summa. So that is insider trading. making use of price-sensitive information for your own gain. I'm sure now they are monitoring it very carefully. There are some sites, there are some WhatsApp groups. All those have to be caught. Because that's otherwise there is no purpose in regulation. So the basic starts from 191 to 200 and becomes tougher when it comes to the securities regime. Then you have two other important sections, 219 and 220. How the director should act in when the company is in an insolvency situation. And 220 says how the director should act when there is serious loss of capital. Now 219, there is only civil liability. If the directors have not informed the shareholders on time that the going is bad, we are in insolvency position, there is a civil liability. You can pay damages or whatever. But 220, serious loss of capital, is pretty serious. Unless you inform the shareholders that the going is bad, and if the shareholders have not given you the blessings to go on for another year, only 1 year, you can be held civil and criminal both. You can end up in jail. So serious loss of capital, especially in group companies, very carefully we check what are the companies which are coming under serious loss of capital, whether you have had those EGMs properly, time frames are given, all that has to be done. So another important section, 219, 220, the directors have to keep in mind. So that is why boards must have very competent company secretaries if you don't have competent lawyers to advise you. So that is another important feature, because the advice has to be, because sometimes you may have a board without a lawyer. So at least the company secretary should advise you and say, well, these are the things, you have the meeting, 220 meeting, serious loss of capital meeting, all that is done and dusted. Now overall, you said, I mentioned 187, 188, 189, then I mentioned 191 to 200, and these two sections. Now that again, that brought in a lot of liability. On top of that, we brought in a lovely section in the Companies Act, section 57, which is called the solvency test. In my books, I always refer to this section as the golden thread that runs across the entire fabric of corporate law in Sri Lanka. Because without solvency, you can't do anything. You can't declare dividends, you can't have tamashas, you can't buy back shares. That came in because of the serious collapses of companies, including banks. From the early 90s, from HPT onwards, there were collapses, one after the other. That was because of this issue. If you look at Golden Key, company was not solvent, but the directors were solvent. In all these cases, I mean, as a practitioner, I can tell you, when these people, directors, come to wind up companies, no money, they can't pay. EPF, ETF, small payments can't make. But they still come in their S-Class and the 7 Series BMW. They are not insolvent. But the company is insolvent. Something radically wrong. Right? So this is very, very common. You ask any of the corporate lawyers, they will say so. Whether to liquidate companies, they come in a three-wheeler, no way. These directors are still good. They are very in a good business. So 57, solvency test is crucial. Due to all those collapses, we introduced solvency test. Now solvency test is just a warning. Solvency test doesn't mean that if the company is not solvent, you have to pack up and go away. Solvency test doesn't say that you have to close shop and run away. No. Solvency test says, if you are not solvent, these are the things you cannot do. That means you tighten your belt, basically. Well, the going is not good. I mean, in families. Because the biggest problem in our jurisdiction is, whether it's individual, corporations or otherwise, with a 2-star income, you try to live a 5-star life. That is the biggest problem. We went into bankruptcy in 2002. We should have gone into bankruptcy 25 years earlier. Our lifestyle. I suppose the younger generation even worse. You look at the credit card cases we file in courts, 200 together. 200 because they are living on credit. So solvency test is a warning to the board. Shareholders don't know whether the company is solvent or not. I always say it's like the red light that comes on your dashboard in your car when your petrol level is low. So then you know that you have to go to the closest petrol shed to pump petrol, otherwise you'll get stuck. So that indication is to the driver. Not to, if you are driving, not to your wife or the children. They are the shareholders. So this solvency warning is to not to the shareholders. But if the directors ignore that, you are in trouble. So the directors have to tighten their belt. Well, when the going is good, you can have tamashas and do whatever. But when the going is bad, you have to live accordingly. It's like, if you have 1,000 rupees in your pocket, and if you want to have a meal, you won't walk into Kingsbury to have a meal. But you won't starve. From 1,000 rupees, you can go to Rahima's and have a good biryani. Or if you want a lower one, you go to and get a bath packet from somewhere, 300 rupees. You won't starve. But you won't go to, with 1,000 rupees, you won't walk into a 5-star hotel to have a meal. So it's like that. So when you have, you limit yourself within your income, within your own budget. My father was a schoolmaster. When he was small, he used to always say, don't be under debt to anyone, not even to a bank. Live within your means. This is something which goes radically wrong. Just because the banks are offering you, just because the lending institutions are offering you. That is why a proper mix of your board is important. A lot of, now, long years ago, the boards were always 60 plus average. Now it's getting a little lower. Right. The problem is, if you have a very young board, the way they look at life is different. I heard one person saying, well, at 50 I did this and, I made the millions by 55. So even if I go to jail at 60, it doesn't matter. Right? So now they are reckless borrowing. Without batting an eyelid, they will borrow $1 million. Our companies can borrow $1 billion. Banks are very nice to people who have money. They always, when you walk into a bank, so why don't you borrow, sir? You can buy, we are promoting this apartment, that apartment, why don't you buy? Right? They want to attract you. We'll give you good rates. Now the rates are low, rates might go up in the future. Why don't you block it and win? So don't get carried away. So directors must be very conscious about these responsibilities that are given to you. Because if these responsibilities are ignored, that the statutory responsibility comes. In fact, once when I was doing this book, Duties of Company Directors and Corporate Governance in Sri Lanka, this was written long time ago, then only I realized, when I was drafting the 534 sections, I didn't know that there are 37 civil liabilities cast on directors and 131 criminal liabilities. Some are not tested yet, but time has come to test them. Right. Just because they are not tested, the Registrar General of Companies will tell you, they are not tested, but still they are in the statute book. There are a couple of important sections, cases which are pending also. Right. So you can't go scot-free. But if you are above board, If you're conscious about your responsibilities, you don't have to worry. Make sure that you are above board, you are transparent in transactions, don't get carried away by your board colleagues. What is your responsibility when you're on the board? All that is important. Now, more than that, there's another important thing which came in recently, which came in August, that is with regard to the just press. The disclosure requirements, I'm not going to spend too much time on that. Now, this came in due to the obligations we have with regard to the Financial Action Task Force and the Asia Pacific anti-group or anti-laundering, money laundering mechanisms. We were compelled to bring this. This came along with a lot of other amendments which are, those are of course cosmetic changes, but this 130 sections bringing beneficial ownership, who a beneficial owner is, and the responsibility cast on the company secretary, and to a certain extent to the regulator and the registrar of companies. Now, registrar of companies is here. You can ask any question from her. She is bringing out 7 forms, BO1 to BO7. It will come within this month, and the regulations will be signed, and it will be out. Thereafter, these responsibilities are there, especially on the company secretary. Poor company secretary is loaded with more work, and maintaining the beneficial ownership records, informing the registrar, because ROC is the repository of all the company forms. So the human individual companies have to register one person, so it will be the company secretary. So the directors will automatically put that responsibility on the company secretary. So it's a huge role for the company secretary. So definition of who of a beneficial owner, it's a human being, 10% human, and it is not easy to find who the beneficial owner is. The idea is, this came in because of, a lot of people were parking their funds, ill-gotten money, right? Terrorist funding, all that. To clear that, now they want to know who the actual owner is, the ultimate owner. So for listed companies, it's going to be a big task, and I'm sure they will get assistance from certain donor agencies to help them. And so this is what the details to be available, all that is there, but that is, again, responsibilities cast. You can get the copy of this and study it more carefully. That brings in a more transparent mechanism to divulge who your shareholders are. Gone are the days, even in Swiss accounts, now you can't have numbered accounts. You have to give the owner's name. All these listed companies, you will have HSBC account number 1, holding shares, trust company owning shares, pension company owning shares. Now they will have to give details. This is only the starting point. Maybe in another 3-4 years, you'll realize how it works. But there are jurisdictions which it has worked. So, above that, I must say, in addition to the role we have, the directors have to be conscious about their duties. One is the Companies Act provisions, then the SEC, the regulatory provisions under the securities regime, and maybe the amendment beneficial thing. But more than that, the directors have another huge role to play because of the new statutes that come. Anyway, EPF, ETF, gratuity, those responsibilities are there. If they are not carried out properly, board is liable. If the company has not paid EPF, board is liable. You will end up in the magistrate court. That is the last space you want to visit. None of these directors want to go and sit on those benches in the magistrate court. They treat you and the drug addict the same way. Just because you wear a tie and coat and go, no special treatment. Right? They are put in that doghouse. So, EPF, ETF, gratuity. Then you have the Consumer Protection Authority. Another important thing. If it's a, Mr. Panditagi knows, if little thing goes to the market, I had that problem once. I had very senior people on my board. They were all hauled up for a cement bag going into the market without the price tag. Because the prices are changing every day, the tags come out. So this has gone. Those are statutory offences. If there is a fine, 10,000 rupee fine, you have to pay. It's like driving over 100, then you pay a fine. But then some lawyers go and argue this. We didn't have the intention. You don't need the intention for statutory crimes. If you drive over 100, you can't say, I was in a hurry to go to the toilet. Your intention is not taken into consideration. You have to pay that fine. So the entire board was summoned to a magistrate court. Because one day that particular lawyer had not gone, and the magistrate summoned. We had similar experiences down south. One of our virgin oil bottles had gone to the market. So you had to pay the fine and get away. So fortunately, I had to file a motion before it was taken, and the fine was 10 years. Some lawyer had been arguing it for 2 years. There was another case, some outdated kiri packet had gone to the market in Kurunegala, and all the foreign directors overseas, 2 Sri Lankan directors, a chartered accountant and a very, very, very senior people, poor man is dead and gone. At the airport, he was stopped and said, you can't leave the country. He didn't even know. Then only realized that there is a court order preventing him from leaving the country for some kiri packet gone to the outdated kiri packet gone to the market. They have got a court order. That also they fought because the foreign company did not want to pay the fine. These poor people had to fight for 5 years and ultimately had to pay the fine. So, Consumer Protection Authority Act, keep in mind that the board has to be conscious. Then you have data protection, electronic transactions. So many new statutes that are being churned out day in, day out. You must have some amount of understanding of these to protect yourself. Then also, there are 2 important provisions of the Companies Act. One is Section 190. You can rely on expert opinion. Right? Not to act in a reckless manner. Okay. Now, if you have expertise on the board, okay, you can rely on him. Now, if there is a banking matter, I'm very lucky on my Tokyo Cement board, I have Dr. Indrajit Kumaraswamy. So I will consult him at the board. And I say, Dr. Kumaraswamy says so, I get it recorded. So we don't have to go any further. You have an expert, and you say, okay, so-and-so says this, that is enough. I mean, if it's a financial matter, maybe your CFO or the Director of Finance is competent enough to give you. Otherwise, you have the right even to go and get expert opinion. Now say if a tax matter comes up, well, my knowledge on tax is very poor. So we will say, okay, why don't we get an opinion from Ernst & Young? Or you can even get 2 opinions from KPMG. So you have guarded yourself by acting in the best interest of the company. You have not acted in a reckless manner. And keep it for a rainy day. All legal opinions, even even emails, then can be produced in court. All those have to be kept. Right? All those have to be kept for a rainy day, because you can use them. When you're on boards, keep in mind, you have to look after yourself. Don't try to look after the other directors. Do look after yourself, because when in trouble, you're alone. So we keep that in mind. All transactions. Now, it's very easy. If you're not happy with some decision, you can send an email to the entire board, copying it to the chairman and to the board and the company secretary, and can be taken up at the board meeting, or even otherwise you have said, well, I have declined on this matter. There are certain instances where I have my single dissent. Sometimes the executive directors can't say no. Sometimes very powerful shareholders are there on boards. They have a lot of pressure, and a lot of people can't say no. We might say, okay, you can't do this, do a proper due diligence, proper financial due diligence, do a proper legal due diligence, marketing due diligence. They say, no, they're all not necessary. Right? If you don't buy this tomorrow, Mr. Dhamika Perra will buy it, Harry Jayawardena will buy it. So, but still you must say, okay, please record my dissent. If something goes wrong, that 189 will tick, whether you have acted in a reckless manner. Then if it goes to court one day, the judge will say, yeah, so-and-so has also told you not to do this. Not all projects are successful. If there is not successful, because there are strong mechanisms for the shareholders and the creditors to take you to the cleaners. Operation mismanagement, 524, 525, 224, 225, then 230 derivative actions. There are several weapons that can be used by the shareholders, minority and majority both. So you have to be conscious about that. So 190 is a good safeguard. Keep in mind and make use of that. Rely on experts, third-party expertise, either internal or external, and keep records of that. Minute it properly. Then there is another section, 218, where you can get indemnity and insurance. Your articles should provide for it. For the very first time, we've introduced that in the Companies Act, where under 218, you can get your D&O cover, Directors and Officers Insurance cover. Now with this new thing, I always advise even the company secretary to be covered with that. I would never join a board if there is no D&O cover. Another important thing for boards, especially for the non-executive directors, to ensure that all these are carried out properly and to have compliance. Banks, of course, compliance is mandatory, but you need a compliance officer also. But even very soon it will come for the listed companies also, for compliance, so that some important person will sign off. You don't know whether EPF has been paid or not. You don't know whether the environmental licenses are in place. You don't know whether there are any pending cases. You don't know whether the software is licensed. How do you know all that? So unless your COO or CFO or compliance officer or a very senior person signs off and says, all payments to the banks are paid up to date, all licenses are in order, especially this environmental license. Right? Now even this can be included now in your compliance, whether we have complied with this. If not, why? So the compliance is a very, very important thing. So for you to guard yourself, you have compliance, you have expertise to obtain 190, and you have directors and officers insurance cover. So lastly, I thought I will share with something. This is like a litany I have brought in my book long years ago. as golden tips that can be taken for all the directors. The rule of why the directors should be more conscious about their role. I have said some golden tips for directors. Well, if you have the book, it's in page 88. You don't have to worry. These are some valuable tips for any director. Be mindful of accepting directorships. Example, do not take over past sins of others. Do not join rogue clubs. Check the history of the company before joining the board. Act in the best interest of the company at all times. Always act in good faith where your bona fides can be established easily when in doubt. Never act in a reckless manner whilst on the board. Never act in a grossly negligent manner whilst on the board. Always rely on your experience and knowledge in business judgment. Do not let your personal interests conflict with the interests of the company. Familiarize yourself with the important provisions of the Companies Act, which can have an impact on your actions on the board. Familiarize yourself with the provisions of the Articles of Association of the company. Note that in the Companies Act, it is specifically stated that the provisions set out therein are in addition to and not in derogation of any provisions contained in any law relating to the duty or liability of directors or officers of a company. Ensure that all statutory obligations of the company, example, EPF, ETF, taxes, etc., are complied with forthwith. Compliance check either monthly or quarterly. Ensure that all banks and other lending institutions are serviced accordingly. Compliance check either monthly or quarterly. Regularly check whether the risk management techniques of the company are in operation. Enterprise risk, strategic risk, so many other risks involved. Note the significance of several other important provisions of the Companies Act that deals with vis-a-vis company name and company number, special provisions applicable to private companies, the solvency test, distributions, the stated capital and capital maintenance, reduction of stated capital, dividends, acquisition of shares, minority buyout rights, meetings, proceedings and resolutions, major transactions. Check whether the financial reporting is done in a professional manner under the provisions of the law. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the Securities and Exchange Commission Act and the SEC rules, which can have an impact on your business. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the listing rules of the Colombo Stock Exchange, which can have an impact on your actions. If the company is listed on the stock exchange, make sure that you are aware of the mandatory code on corporate governance and also the voluntary code on corporate governance. Even if the company is not listed, try to follow the corporate governance mechanisms in place of good governance. Consider the mechanisms of corporate social responsibility for the company, CSR. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you are aware of the provisions of the Banking Act, which can have an impact on your actions. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you are aware of the provisions of the directions made under the Banking Act, which can have an impact on your actions. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you have the guidelines of the internal controls published by the Institute of Chartered Accountants of Sri Lanka. If the company is a registered finance company, make sure that you are aware of the provisions of the Finance Companies Act and the directions made under the said Act, which can have an impact on your actions. If the company is a registered finance leasing company, make sure that you are aware of the provisions of the Finance Leasing Act and directions made under the said Act, which can have an impact on your actions. If the company is a specialized entity, make sure that you are aware of the provisions of the statute or statutes, which can have an impact on your actions in addition to the provisions of the Companies Act referred to above. Be mindful of your actions that can be impeached by the company, directors, shareholders, creditors, and other stakeholders under the provisions of the Companies Act. Be mindful of oppression and mismanagement actions and derivative actions that can be instituted by minority shareholders, impeaching actions of directors. If the company is a conglomerate or a group entity, ensure that you have a fair knowledge on holding companies, subsidiary companies, and associate companies and their respective roles under the law. Check whether the consolidated accounts or group accounts are done accordingly if it is a group entity. Be mindful of related party transactions of the company. Ensure that all disclosures are made under the law. Use your conscience when taking decisions at board level. Make use of your own expertise when you have a superior knowledge on the subject. Never let others who are lesser knowledgeable on the subject matter in issue pressurize you to change your decision. Always ensure that independent directors are truly independent. Always ensure that the board recognizes the views of independent directors. Do not be under obligation to the chairman or any other member on the board. Have an independent mind of your own. Ensure that your dissent on any matter is recorded correctly at meetings. Check the board minutes and minutes of other committees where you are a party with care. Read the board minutes with absolute care before they are confirmed. See that the board minutes and other minutes of committees are corrected accordingly. Note that board minutes are treated as a contemporaneous record of events and matters. If you are not an expert on the matter in issue, ensure that you are rely on third-party expertise on the matter, either at board level or externally. Keep records of same. Use of information and advice of third parties is permitted under Section 190 of the Companies Act with clarity. Any individual on the board can rely on third-party expertise in given circumstances. Always remember to keep such advice on record to be used as evidence when needed later, legal opinions, emails, etc. Be aware of the provisions of the Company Act and other relevant statutes which attract personal liability, including criminal liability, which again is personal in nature. Make use of the directors' and officers' insurance cover. Ensure that a proper interest register is maintained by the company and all relevant interests of directors, including yours, are duly entered in the said register. Make use of Section 526 when needed to obtain appropriate relief from court. Make note of actions that attract personal liability, civil and criminal, as set out in other statutes or statutes that impact on the company. Ensure that all your actions are carried out in a professional manner, reasonably with dignity and honesty. Independent non-executive directors are invited to boards mainly due to their expertise, example, expert in finance, expert in law, expert in marketing, etc. Ensure that such expertise is made use by the board and not ignored. If you feel uncomfortable on the board, exit forthwith. Independent directors should resign no sooner they feel their independence is eroded. Do not accept board appointments if you cannot dedicate sufficient time for board matters. Do not accept too many directorships if you cannot dedicate sufficient time for each directorship. Be aware of your rights as director under the Companies Act, example, privy to board minutes. Check whether the CEO is performing his obligations correctly. Check whether the subcommittees of the board are in operation in the correct manner. Check whether the company external auditor is performing his rights professionally. Check whether the company secretary is performing his rights professionally. Ensure that the internal audit mechanisms of the company are in order. Be familiar with SLAs that may have an impact on your company. Also note that Sri Lanka follows the IFRS reporting standards. A new one, S1 and S2 ESG reporting. That also you must keep in mind. When I wrote this book, it was not there. Avoid being a mere passenger on the board, endorsing all decisions of the board in a passive manner. Be cautious when giving personal guarantees for corporate benefit. Remember that ignorance is no excuse. Remember that accepting a directorship is not joining a cocktail circuit. Never discuss boardroom matters with family members. Never discuss boardroom matters with friends or associates. Do not disseminate price-sensitive corporate information to any third party who is not entitled to know them. Do not trade your principles for money. Thank you very much.
Thank you very much, Dr. Cabral. Your insights into directors' duties, accountability, and the evolving legal landscape are truly invaluable. As we proceed to the panel discussion and Q&A session, focusing on practical challenges and legal risk faced by directors of listed companies. This session brings together an eminent panel of professionals who will share their expertise and experiences on this critical topic. Allow me to introduce our distinguished panelists, Dr. Harsha Cabral, President's Counsel, Mr. Laknath Jayavikrama, Commission Member of the Securities and Exchange Commission of Sri Lanka, Mr. Renuka Wijayawardena, former Chief Regulatory Officer and Consultant, Colombo Stock Exchange, Mr. Bueneka Basnayaka, Partner at FJ&G Diserum, Ms. Sunetra Dharmakithri, Registrar of Companies, and the discussion will be moderated by Ms. Chandani Veragala, Consultant Company Secretary at Nexus Corporate Consultancies Private Limited. Let's warmly welcome the moderator and the panelists as they take their seats.
Good evening, ladies and gentlemen. So we are now ready to commence the second part of the seminar today to commence the panel discussion. We are really honored to have this eminent panel here today to share their knowledge with the distinguished audience representing the listed companies. In the panel discussion, we are trying to share their practical experience and knowledge. Now, the director's liabilities and duties, that section was very well covered by our keynote speaker, Dr. Cabral. So, in the panel discussion, we'll try and we'll share the practical experience and the knowledge gained by our eminent panel members through their practical experience in different areas. So let me start the panel discussion. Mr. Jayavikrama, as a member of the commission and your capacity as an independent director of several listed companies, how do you view the extent to which directors may appropriately rely on information and analysis provided by management and external experts when making board decisions?
Okay, thank you. Like Dr. Cabral mentioned, under section 189, when we are performing duties as directors, we have to act in a manner which is not reckless or we should not be negligent. So then there is a question, how could we do that one? So then we take our decisions based on the information. How do we get this information? For me, the information come to the board generally as board papers in practical sense. So in my experience, I would like to list out the different ways in which the information reaches to the board. First one is the timely updated board papers, either through software or hard copies. They are well in advance received to us. That is number one. Then the second one is the last minute board papers. So we all know that however much we plan, last minute there will be number of board papers. Thirdly, we may have on the day of the board meeting, there will be distributed papers. That also will happen. Apart from that, management may also do presentations to the board. That is also information to the board. Apart from the presentation, which is probably in PowerPoint form, but they may give oral explanations. Why I have categorized all that is, with every category has a different meaning. Because like Dr. Cabral said, when we take the decision, the section 190 says we have to have the ability to make proper inquiries. If we don't make proper inquiries, we may not be able to give the proper decision. So my submission to this educated audience is that if we are getting the board papers in advance, well in advance, yes, I can make queries, adequate queries. But if we are getting the board papers on the last minute, I may not be able to do so. So that means my ability to ask the right question is eroded. So therefore, I have a small grid developed by me when I also do certain lectures on the corporate law. I teach this model where reliance on the management information can be accepted at very high level, or it may not be accepted under different criteria. One is the timing. If the management provides the information on timely basis in advance, I would say that I can rely on that information. But if they provide the information at a very late stage, I can't say so. Number two, if the information provided by the management is within the domain knowledge of the director, let's say I am an accountant or a lawyer, if that information is in my domain knowledge, so I should be able to analyze on my own. I don't have to rely on their information, solely on their information. But if it is outside the domain knowledge, yes, of course, I have to rely on that one. Third one is the capacity of the provider, external, let's say external lawyer, valuer, or a consultant. If he is qualified, appropriately experienced, yes, I can rely on that one. If not, I may not be able to rely. There are few other things I have observed in Sri Lankan context. Language of the board papers. Some board papers, very precise, clear, given proper conclusions. Some are ambiguous. They don't give proper conclusions. When we don't have the proper conclusion, as a director, we are not sure whether the person who is forwarding the board resolution has made up his mind, or has he come to a proper conclusion. So in that type of situation, I think it would be difficult to rely on that one. Then I think Dr. Cabral might elaborate. There is a new school of thought developing from Australian side, whether the certain activities, certain topics can be delegable, or can that be delegated to others. If it is delegatable or delegable, of course, we can accept. If not, we should not rely on that one. So that is a summary in practical sense.
Thank you. Thank you, Mr. Charikrama. So my next question is to Mr. Renuka Wijewardena. So given your deep understanding of market operations, what measures should boards of listed companies adopt to strengthen the financial resilience and avoid sliding into distress or insolvency, especially in a volatile economic environment? So how can directors play a more active role in recognizing early red flags and steering timely corrective action?
Thank you. Thank you very much to SEC for inviting me for this. This actually requires a very long answer. I'll try to summarize it as much as possible. The legality of it, I'm sure Dr. Harsha Cabral elaborated in detail. So as far as the CSC and SEC are concerned, there is a framework available in the SEC Act as well as in the listing rules. Your question was mainly on companies getting into financial difficulty, distress situations. But I must tell you, it doesn't happen overnight, right? There are triggers. There are indicators there are early indicators. So as directors of listed companies, there should be, you should have the capacity of understanding it in a very timely manner. And most of these triggers actually relate to the financial statements, the transparency, integrity, and the timeliness of financial statements. So as directors, you should not leave that to the accounting person. I think in most boards, that's what happens. Everything is handed over to the audit committee chairman, who is also an accounting professional. Others are just relaxing. No, you can't do that. Because these are the early signs which can blow up into a real catastrophe. That's what has happened globally as well as in the Sri Lankan context also. So there are many things you can do. Actually, starting point, I think Dr. Harsha Cabral mentioned getting the right people to board, right? So I know our listing rules talk of the corporate governance rules give the framework, but mostly in terms of independence, our corporate governance rules talk of who you should not be. What are the impediments to independence? We now, if they are a shareholder or related party or relationship, you are not independent. So the rules actually address that part. But what happens practically is that independence actually is much more than that. You must have sound independent judgment. I think that's one of the key criteria in addition to many others like accountability, etc. So, which is difficult to judge. I know the fit and proper rules also talk of competence and all that. But we have largely left it to the company. So the starting point is getting the right mix of directors with the right skills, right understanding. Then there is a lot of responsibility that is given to the audit committee, which is set out in the rules. I'm sure the Institute of Chartered Accountants Best Practice Code also talks of a lot of these things, which is a voluntary code. Our one is the mandatory rule provision. So every board member should understand their role and perform those duties. As I said, there are early triggers. So, for example, if there are delays in preparation of financial statements, so if there's reluctance by the secretary management in giving information, if accounts are restated very often, and if there are problems with the auditors, auditors are reluctant, so you should be very proactive. We have had instances where the audit committee gets the audited accounts and the accounts are qualified. Then they start firefighting. It's too late because either way you get caught. If you have a qualification, there are enforcement steps that are set out in the rules. And if you try to resolve the matters with the auditor without releasing it, then you are delaying the release. So either way you get caught, so that's too late. So especially the audit committee, that should be the conduit between the company and the auditors. You have to be very proactive. You have to, basically, what we are saying is, be vigilant, be very, very, not that you need to, we are not saying, micromanagement or managing the company. You leave it to the executive staff. But there should be very clear oversight of the affairs of the company. Then certain key people leaving the organization, which is a red flag actually. So for example, some of the key people, they start leaving, including the independent director. So that will tell you there's something not very right that is going on. Including the auditor. Sometimes auditor may be reluctant to do the future audits. Now, listing rules talk of if the company wants to change auditor, when the auditor has given some qualified statement, there's a process that is set out in the listing rules. You have to have a justification and rationale as to why you want to change it if the previous accounts are qualified. So those are some of the trigger points. Then generally lack of a corporate governance, good governance culture, compliance-oriented culture. I know companies which are regulated by central bank and maybe other regulatory bodies, you may not see it that much, but we are not talking only about them. There are nearly 290 companies. I'm sure most of you are representing those companies. So you need to be very vigilant. Don't leave it to just, as I think Harsha said, that everybody is treated in the same way. When fines are imposed, it's not only for the executive directors, it's for all directors. And if in the unlikely event of the company getting delisted, you lose your fit and proper. You can't be a director of a listed company. I don't think very many are aware of it. Under the new delisting rules, the moment the stock exchange delists you, it's not a voluntary delisting. If it is a mandatory delisting, you lose the fit and proper, your propriety. So you can't be on the board for 3 years or something, right? So it's very important that you understand these things. So these are some of the early triggers that you can think in addition to, I'm not an accountant, so you probably know the debt to equity ratio, the cash flow situation, the operative cash flow situation. There's a sharp decline. There are major, some related party transactions, because sometimes it's the related party transactions that trigger some of these issues. So I know we have structures, but as directors, you have to be very careful about some of these things. So we can discuss all these things in detail. So that's my initial response to this.
Thank you, Mr. Vijayardhan, for that explanation. So, Mr. Vonika Basnaika. So in today's increasingly regulated environment, listed companies face enhanced scrutiny from the regulators, shareholders, and the public. From a legal perspective, what are the most effective strategies that listed companies can adopt to ensure ongoing compliance with corporate, securities, and governance regulation to build a strong culture of accountability?
Thank you, Mrs. Veeragala. So essentially, compliance is all about what you should do. At a fundamental level, that is what you should do and shouldn't do. Before I go into that, I would take a step back and go into what a company can do and cannot do. And that is all articulated in Section 2 of the Companies Act, which I consider as one of the most important sections in the Companies Act, which talks about the capacity of a company to carry on its business. So what Section 2 says is, subject to the articles, so the articles can have restrictions with regard to the conduct of business. Specifically, if you look at the object clause will say, will set out the businesses that the company can carry on. Then the activities of the company will be restricted to what is set out in the objects. Then the section goes on to say that the company will also have all the powers, rights, and privileges for purposes of the businesses that the company carries out, subject to written law. So the written law will set out all the compliance requirements that the company will have to adhere to. This could be in the context of all companies, the Companies Act, with regard to any company that carries on regulated business, banks, finance companies, any industry that requires environmental approvals, and in the context of all listed companies, the SEC Act and the listing rules. So the activities, the powers, the businesses, whatever that the company has to do, can do, the company will have to ensure that it complies with all legal and regulatory requirements on an ongoing basis as well as on a contingency basis. So ongoing compliances would be the requirement to have annual general meetings, filing statutory forms, and all that under the Companies Act. And in the context of listed companies, you have the ongoing listing requirements in Rule 7.6 as well as Rule 9. The practical steps, before we go into practical steps, of course, the effective means by which compliance can be achieved is through effective delegation of functions. Dr. Cabral mentioned section 184 and 186. So 184 is where the board is conferred with the authority to conduct business and manage the business of the company. The board is also given the power to delegate its functions, either to a committee of directors. It could be a director, a single director. It could be an employee or a group of employees, or it could even be any other person, could be a third party. So it is impracticable for the board of directors as a collective or each individual director to look into all compliance aspects. So delegation is a key component of compliance. Effective delegation has to be there. So what is delegation? So in a company in the business of a company, you have various functions, like you have the HR functions, you have finance, you have the legal compliance. So all these functions will have to be delegated to the relevant experts, those who have relevant expertise in those areas. That way the directors not only delegate their functions and authority, but they also share responsibility with these relevant expertise who are in these various functions. So in order to look at the practical steps that a company or practical measures that the companies take, which we see increasingly when dealing with in advisor capacity is, so once delegation has taken place, the preparatory work, that is to be aware of what the compliance obligations are, and also to have a checklist of compliance requirements that they will have to adhere to on an ongoing basis as well as on a contingency basis. So that is where proper, well-articulated, well-formulated action plans with timelines will be useful for each of these departments or functional units within a company to ensure that each compliance requirement is met in a timely manner and in accordance with the timelines stipulated within the law. So having those processes, having those preparatory steps is important. Periodic awareness programs to educate those who are in charge or responsible for handling these functions is also important. And at the same time, it it is critically important that you have a proper implementation mechanism, because it's all well and good to have the mechanisms in place. It's all well and good to have the systems in place, but if the implementation is lax, you will anyway get into trouble. You will see that you fall behind on all necessary compliances, and it will be too late when you find out that, okay, the entire compliance structure, compliance culture has broken down. So all these measures are important in order to ensure that the company remains, or company maintains a compliance centric or compliance conscious culture, maintains, and also you have to evolve and adapt over time, because the legal framework is changing all the time. So the compliance checklists and whatever awareness programs also will have to evolve to ensure that you are, the respective companies are keeping abreast of all developments, and the compliance framework is also evolved in order to meet all challenges. Those are my initial thoughts on that.
Thank you very much. So now we are getting back to our keynote speaker. We discussed about the latest amendment to the Companies Act, introducing the UBO provision. So Dr. Cabral, considering the beneficial ownership provisions introduced by the Companies Act number 12 of 2025, what practical steps should listed companies take to identify and maintain records of relevant interest and beneficial owners, and how can they ensure timely and accurate disclosure to both the Colombo Stock Exchange and to the Registrar General of Companies? You, yes, no, to you. No, yeah, ROC, yes, over to you.
Yeah, in the sections, amended section 130A to J deals with the obligations. I have a separate column which says responsibilities. There is only one section where the depositors EDS comes in. So they will have to ensure that they maintain the records, but still I think Reduka will be in a better position to say how they are going to deal with. It is up to the company secretary of the company to divulge whatever information they have with regard to the listed entity beneficial ownership, and the inability to divulge the information. There is a particular clause in 130 amendment which says that you might lose the right of the share. So you might not be able to vote or use any of the rights of those shares if you don't divulge the information. So how the regulator will look at that aspect, and how far you can go to look at the correct details, all will come in the regulations. And I believe they will have to get some assistance from jurisdictions where they have applied this already.
Thank you very much, Mrs. Veeragal, and also thank you so much for the senior panelist. So actually, when I adding something to the previous discussion, so I think it's better if I can come from the start point. So let's say who is a beneficial owner. So in addition to the detailed explanation done by Dr. Harsha Cabral. So when we take an example as a company, so there is a company called A. So in that company, let's say there are two shareholders. So one is a natural person, the other one is a legal person. So when we take that example, so we have to dig until we find the ultimate natural person who is holding shares. So that is the simple interpretation of the ultimate beneficial owner. So when we go up to that step, so there are a lot of requirements from the companies. So when we comes to the section 100, I'll start from the section 130H because that is relevant for the existing companies. Before we go to the new companies, we have to start from the existing companies. So let's say when we go to the existing companies, fortunately if the act is passed, but still we have not finalized the forms and also the regulation. So therefore you have time to ready for those things. So when we comes to the section 130H, you have to disclose the information of the ultimate beneficial owners of the existing companies within 6 months from the date of the operation of the new Companies Act, right? So why I start from that point is, before you come to the next level, you should update the information of the existing companies. No? In addition to that, if it is a company listed at the stock exchange, you have to share the ultimate beneficial owner information through the CSC, as a CSC type data to the register of companies, not within 6 months, but within 30 days, but from the date of the operation of the new Companies Act. So that is the practical requirement of the register of companies should be complied by the company. So now when we come to the first step, so if it is a new company incorporation, definitely you have to submit the normal documents for the company incorporation, but also together with the BO form, that is BO1, together with the normal incorporation documents, you have to submit BO1. Unfortunately, still we have not developed the system, so therefore you have to come through another system. We are planning to develop another system to submit beneficial owner information. So if it is an incorporation, BO1 should be submitted together with those forms. The gazetted fees will be informed. So if it is a share issue, new share issue, also again you have to submit the beneficial BO2 form together with the normal form 6 and also together with the resolution passed by the directors. Not only that, if it is a share transfer, when the practical ways to submit a share transfer currently with the form annual return. So when you file, then after the new act comes, when you file an annual return, together with that annual return, again you have to file those new share transfer information together with the BO information. That is now currently Form 3, definitely it won't be changed, but Form 3. So, and also we have to say that every director or every secretary should inform those information to the register of companies within 30 working days. But every director and every company secretary is liable to inform those information when they are aware about that from their shareholders. From then only the company secretaries and the directors are liable. And also if there are, in addition to that, if there are any changes of a beneficial owner, for example, say that the beneficial owner's address has been changed. Again, you have to inform as our normal forms, you have to inform to the register of companies together with the specially generated form 7. So together with that annual return also, I couldn't mention that is form 5. But all those are for the local companies. You know that if it is a private company or a public company or a listed company, as the senior panelist stated, not without considering the type of the company, for all the companies you have to disclose all these information. But the problem is here, if it is an overseas company or else offshore company, so for those companies also you have to anyhow you have to disclose the ultimate beneficial owners of the company. So I don't know. So you all know that if it is an overseas company or an overseas company, there are no directors, no shareholders in here Sri Lankan branch officers. So all those directors and shareholders and also the company secretaries are with the mother company in outside countries. So, but however, this responsibility will go up to that level. So I don't know whether it is practical or not, but the provision is there. So however, if it is an overseas company or an offshore company, and also if it is a port city company is also considering as one type of offshore company. So all these companies also you have to submit those information. And when just after you have submitted those information to the register of companies under the prescribed period, so ROC responsibility is to collect all those data and verify those data and store those data. So our responsibility is to maintain a beneficial owner register. So probably it will be a soft version. So as now the incorporation register, but however, we have to maintain, but in addition to that, we'll try to validate in NIC numbers and the passport numbers of the beneficial owners through the system. So already we have discussed with the register of persons. So whenever the registrar's person is ready to share their data with the register of companies, we will implement that up to, until then we'll take the NIC copies, and they are, in the register of persons they have a separate system to validate NIC data through their separate system. So even now we are validating all the NIC data through that system. So likewise we'll try to validate those data through the system. So in addition to that, how we issue the certified copies of those beneficial owners information. Not like the normal forms, but we have to issue certified copies of those beneficial owners forms, not as a PDF document, but as a data sheet, because in those beneficial owner forms, we'll take a lot of data, maybe sometimes personal data. So all those data we can't issue as public. So when you refer the new amendment, you can see that some data will be public, some data won't be public. So some data only we can share with the law enforcement authorities. So likewise, there are some restrictions. So therefore, we'll plan to issue certified, however we'll issue certified copies, we'll issue certified copies as a data mode. So however, we are planning to issue certified copies to provide the services. And when it comes to the penalty clauses, so and also ROC has a provision to give some directions to the company. If the companies are not fulfilling the requirements of the Act, so we can give some directions to companies asking you all to fulfill those requirements. So if it is not done, again, there is a penalty clause, and also you can see that there is a offences if you all are failing to comply the subsection 1, 3, 4, 7 and 8 of 130A, you will be penalized up to 1 million rupees, and also with 10 years imprisonment. That is very, I don't know whether it's fair or unfair, but anyway, the provision is there. So if you are failing to comply those requirements, the offenses like this, and also if you are knowingly provide false information, and also it will go up to knowing withholds details. If you are knowing, you can't hold those details. Also, you can share wrong records. So for all these instances, the same penalties and same imprisonments. So, and also for all those matters, directors and the company secretary and also the authorized person also will be guilty. So these are the provisions which is relevant to the register of companies. In addition to that, when we comes to the second part of your question, Mrs. Veeragala, so how to enhance the corporate transparency implementing these provisions. So actually, I think that these provisions are more than enough to enhance the corporate transparency, but however, when we comply all those requirements, automatically the corporate transparency will be enhanced. So, because there are a lot of penalty clauses, a lot of directions, and also offenses. So, I can say that corporate transparency also will be enhanced. So, in addition to that, I'll tell any other additional thing. So, technical infrastructure, which is ready from the Register of Companies side, still now we have taken all the approvals to implement this law. In addition to that, we have taken the World Bank, IMF, and also all the other stakeholder organizations. We have had multiple discussions and we have taken a lot of comments and thoughts. So now, before December, we are planning to develop the system, and just after we have developed the system, we can sign the forms and regulations, because until we develop the system, we have hold the forms and regulations to be signed, because just after we have signed the regulations and forms, we have to implement the law. So we are still not ready to implement the law, since we are not ready to develop the system. So therefore, just after we have developed the system to facilitate the companies to submit their information, we will be ready to implement this beneficial owner concept. Thank you.
Thank you very much, Mrs. Thank you very much, Mrs. for your detailed explanation about the practical side, how we are going to implement, and the register of companies, how they are going to implement the system. Can I make a small clarification from Dr. Cabral? You mentioned that it is the authorized officer to be appointed by the company, and that person has to be a natural person to maintain the UBO register and the UBO information. So my question is, it is the understanding of that is now that this officer should be the company secretary, but when the company secretary is an outsourced to a company, to a private company, how can the listed entities handle this situation?
That is specifically dealt with in the section itself. If you look at 130 subsection C. 130C says, natural person shall be appointed by the company for the safekeeping and making available details of beneficial ownership. So very often the company will that function, the conduit between the company and the ROC is the company secretary. So now you have to appoint a human being, and if the company secretary function is outsourced to a firm, that firm will have to nominate an individual human being. So it is very clearly set out in the section.
Thank you. It's clarified. So I'll get back to Ms. Renuku Joadhan again. Now there was a recent amendment to Section 211 of the Companies Act, and it's clarified that the reappointment of directors who has attained the age of 70 years or more at an AGM will be valid till the next AGM, provided that the AGM subject to the section 133(1) of the principal enactment. That means you have to have the next AGM within 6 months from the financial year end, and there cannot be a gap between more than 15 months between the two AGMs. And the listing rules are also amended in respect of these independency of directors recently in March 2025. So, given these Companies Act amendment and as well as the listing rule amendments, how does this apply to a continuance of independency of a listed company director who has reached the age of 70 years?
Yeah, that's an interesting scenario. I know the new Companies Act amendments has clarified the position with regard to the continuation of a director who is more than 70, but that's a statutory provision. Now, our rules are relating to the independence of the person. So the rule still remains actually. If you are over 70, you are not independent. But of course, rules since March or April this year, we have given some leeway where if the listed company follows a certain process, like for example, the Nominations and Governance Committee can give a basis, and then that has to be approved by the board, then it has to be approved by the shareholders in a manner that majority of the public shareholders will have to approve the independence. But all that will have to happen before the person reaches the age 70. Although this amendment gives a period of whatever, 15 months or whatever, that is to remain on the board as a director. Now here it's much more stricter, right? So you have to do all that. If you want to keep that person as independent director, you have to do all that before he attains the age of 70. Now when this rule came in, there were certain directors who were already 70. So we had given some leeway to them. That is explained in one of our frequently asked questions actually. If you go to the CSE website, we have given certain scenarios. So now, for example, the rule came in March this year, so you can't have the AGM next day, no? So AGMs are held usually latter part of the year. So during that period, that person can be considered independent. But I think in the rule itself, there was a provision given where 1 year period was given for the company to have the next AGM and get it approved. So the 1 year will come to conclusion probably next April. But by that time, company would have non-complied with. I mean, I don't think a lot of companies are there like that. Basically, just to simplify the matters, the director has to, if the director wants to, if the company wants to keep him as an independent director, all those approvals will have to be obtained before, not making use of, not relying on the amendments to the Companies Act.
Okay, thank you. Now, Mr. Bonica. Regarding Rule 9.10.3 of the listing rules and Section 207(2) of the Companies Act, when exactly should a listed company publish a market announcement about a director's resignation? And what factors should be considered to ensure that the timing of the announcement complies with both regulatory requirements and good corporate governance?
So the listing rules is pretty clear. So you need to make an immediate disclosure, market announcement of a resignation of a director. So immediate disclosure when a resignation takes place. So then it all boils down to the effective date of the resignation, as to when the resignation becomes effective. On this, the Companies Act is also very clear. Companies Act Section 207 says, a resignation of a director, so a director can resign by issuing a letter of resignation to the registered office of the company, and the resignation becomes effective on the receipt by the company of the resignation letter, or if the letter specifies a later date on which the resignation is to become effective, on that later date, right? So I can explain that with a few scenarios. With a few hypothetical dates also. Now we are in November. So if a director issues a resignation letter to the company and the company receives it on the 15th of November, and the letter doesn't specify a date of resignation, then the effective date of resignation is 15th November. It's very clear. But if the letter says, even though it's received by the company on the 15th of November, if the letter says my resignation will become effective on the 30th of November, then the resignation is effective on the 30th. The disclosure has to be made on the after 30th. In the previous example, where the resignation becomes effective on the 15th of November when the company receives it, the announcement has to go immediately after that. So it can be 15th. If it is impracticable to make the disclosure on the 15th, maybe 16th. But it's immediate. Immediate is a question of fact, it's subjective. Then another scenario is a letter is received by the company on the 15th, but it is dated 10th of November. Or the letter says, my resignation is effective on the 12th of November, even though the company receives it on the 15th. So in that scenario, the letter is dated on the 10th. The letter says resignation is effective on the 12th. Company receives it on the 15th. Then the resignation should be, the effective date of the resignation is actually 15th of November because the company receives it on that date. Because the Companies Act doesn't say where the Companies Act only says the resignation will become effective if a date is specified in the letter, only if that is a later date, not an earlier date. So these scenarios, I think, clearly explains how the company should treat the effective date of the resignation when the company receives a letter from a director indicating his desire to resign from the board.
Permit me to add a few other points also. This is even more complicated with regard to resignations of directors who are subject to central bank regulation. Because that's a bit of a complicated scenario. So then the resignation is actually valid when the central bank approves that. Now, you could have a bit of a time period between all these dates and the central bank approval date. And we understand that sometimes central bank puts conditions which will have to go back to the board, right? So I think we might need to, Nilupa, we might need to take it up with the central bank, and because their focus is not investor protection, Chairman, their focus is basically sustenance of the price stability and system stability. So, but now the share is trading. Information may be available with some people, may not be available with others, so you can't run a fair and orderly market that way. So we need to minimize that time period. So if central bank approves it as it is, I think immediate disclosure is necessary. But my understanding is sometimes central bank imposes conditions, which will have to be discussed with at the next board meeting, which is held in the next month. Now we are talking about another 2 months period. It's somewhat complicated.
Just to add I give you some free legal advice on this matter. When you're tendering your resignation, make sure that you inform the company. You can address it to the chairman or the managing director. Copy it to the company secretary and copy it to the regulator if it's a listed entity. And if you can go further, if there are any exposures, I may copy it to the several banks also to ensure, because then it's transparent. And there is another wrong notion, thinking that when you resign, the company has to accept it. There is nothing called that. There is nothing called acceptance. You tender your resignation except with the exception Renuka mentioned about regulatory issues of the central bank. You have the director bank supervision and director non-bank supervision, 2 categories. Other than that, once you tender your resignation, as Bhuvanika said, the Companies Act deals with that, receipt of at the document at this thing. There's nothing called acceptance. So don't think that the company can reject you're not accepting this thing. You can't say that. There is no offer and acceptance coming into that.
Okay, thank you very much, all the panel members. I think we can now sum up the panel discussion, and we can allocate certain time for the audience to raise any question relevant to the discussions we made to any of the panel members, if you wish to do so. anybody wants to raise a question, please raise your hand and then we can provide a mic. It seems that there are no questions from the audience, so that means that you all have understood everything very well. So it's time to sum up the discussion, and so we'll conclude the panel discussion. Over to the computer.
Thank you to our moderator and all the panelists for that engaging and insightful discussion. The practical perspectives shared today truly help to bridge the gap between regulation and boardroom realities. May I request our panelists and the moderator to kindly remain on stage, while I would like to take this privilege to invite Senior Professor Harindra Disabandara, Chairman of the SEC Sri Lanka, to join us on stage. As a gesture of our sincere appreciation, we are pleased to present a token of appreciation to Dr. Harsha Cabral in recognition of his contribution as the keynote speaker this evening. We would now like to take a moment to express our gratitude to our panelists and moderator for their valuable contribution in this event, Mr. Lakna Javikrama, Mr. Renuka Vijayawardana, Mr. Bueneka Basnaika, Ms. Sunetra Dharmakirti, and finally Ms. Chandani Veragala. Thank you very much, Professor Disabandara, and our heartfelt appreciation once again to all our panelists and the moderator. Ladies and gentlemen, as we draw this session to a close, on behalf of the Securities and Exchange Commission, I extend our sincere appreciation to all our speakers, panelists, and the participants for making this event a success. We hope today's discussions have deepened your understanding of directors' liabilities and strengthened your commitment to sound corporate governance. Thank you for your active participation and for joining us this evening. Please do enjoy the refreshments that we have arranged for you. Good night.